wonder, does that help? But this is the decision here. The Court of Common Pleas, Philadelphia County Criminal Division, Trial Division, March 31st, today, 2023. Order and opinion, Lucretia Clemons, J. And now this 31st day of March 2023, upon consideration of defendant's counseled petition for habeas corpus relief pursuant to Article 1, Section 14 of the Pennsylvania Constitution and statutory post-conviction relief under 42 PACS 9542 et sec and Consolidated Memorandum of Law, PCRA petition. Defendant's petition is dismissed without a hearing for the reasons set forth below. This is the defendant's sixth counseled PCRA petition. It raises three issues premised upon documents that the Philadelphia District Attorney's Office disclosed to defendant on or about January 3rd, 2019. First, defendant argues that the trial prosecutor's recently disclosed handwritten notes from jury selection are evidence that the prosecutor violated Batson versus Kentucky by exercising preemptory strikes to purposefully exclude Black prospective jurors. Second, defendant asserts that the Commonwealth violated Brady versus Maryland by withholding evidence that an eyewitness, Robert Chaubert, may have been promised compensation for his trial testimony that he saw defendant shoot Officer Faulkner. Third, defendant asserts that the Commonwealth violated Brady by withholding evidence that a second eyewitness, Cynthia White, may have been promised leniency in her future prosecutions in exchange for her testimony that she saw defendant shoot Officer Faulkner. I'll put the links in the show description, but please just be reminded that on this platform alone, we've talked with many of the experts related to this trial, covering all three of these claims and explaining in great detail why the claims make sense. And I'll invite, Professor Schiffman and Johanna Fernandez and Dr. Burrows and Lynn Washington, Mama Julia Wright, and more. Everyone will be invited at their convenience, Pam Africa, to come back and talk more about why they feel that the judge here has ruled incorrectly. And of course, what they'd like to see us do next. But anyway, just a heads up that these First, defendant's Batson claim is time barred and waived, so this court does not have jurisdiction to reach it. Second, defendant's Brady's claim lack merit, even if the court accepts all the defendant's proffered facts as true, considers what defendant could present at an evidentiary hearing, and draws all reasonable inferences in defendant's favor. Defendant cannot show that the alleged Brady information was material to his first-degree murder conviction. For the reasons herein, defendant's sixth PCRA petition is subject to dismissal. So again, we'll have to get the experts in here to assess why what we're about to see in her explanation is insufficient. I think we should have time to get through the whole document, but yeah, because there are cases when they laid them out here. I mean, and even when I saw them presented in the hearing back in last December in one of the hearings, I don't see how. Well, how would I know? I'm not the expert here. It seems that they had a stronger case, but Anyway, the history of the past 40 years of post-conviction litigation is helpful for understanding the procedural posture of defendant's current petition. On July 2nd, 1982, a jury found defendant guilty of fatally shooting Philadelphia police officer Daniel Faulkner. Defendant was convicted of first-degree murder and possessing an instrument of crime. On July 3rd, 1982, after a penalty phase hearing, defendant was sentenced to death. On March 6th, 1989, the Supreme Court of Pennsylvania affirmed defendant's conviction on direct appeal. The Supreme Court of the United States denied defendant's petition for a writ of certiorari on October 1st, 1990. Defendant filed a timely first PCRA petition, which was dismissed after an extensive evidentiary hearing. On October 29, 1998, the Supreme Court of Pennsylvania affirmed dismissal of defendant's first PCRA petition. Defendants next litigated a habeas corpus petition in the United States District Court for the Eastern District of Pennsylvania. On December 18, 2001, the Honorable William Hendricks Yohn granted limited relief on defendant's penalty phase claims and ordered the defendant's death sentence be vacated. And you know what, everybody? Hold on 1 second. Bear with me. Sorry, everybody. I think it seems like yeah, like I said, I'm not sure if anybody was going to be joining. I think that was Pam Africa attempting to connect, and we'll see if she's able to work that out. If I'm not sure, but anyway, whether she can now or later, whether she can now or not is it's okay. Whenever it's possible, we'll have her and others join us. So anyway, but by the way, just in terms of what is being said here in this the denial statement here from the judge, even in our last conversation, and again, I'll make sure all the links are in the show description. Even in our last conversation with Lynn Washington, again, I'm not by far from the expert here, but it seems like just even in that last conversation, never mind the other ones more recently with everybody else, it seems like all of these issues had been more than explained, including the fact that the handwritten notes showing the attempt to deny Mumia his rights in on the issue of the Batson case, that is the setting up of the denial of black jurors, that was revealed well after all of some of these PCRA hearings. So he should, which they were arguing should have not put them under that time bar that the judge described at the beginning. So, but anyway, we'll wait, and when they can join us, they certainly will. In 2016, defendant filed his fifth PCRA petition. The PCRA court granted partial relief by reinstating defendant's direct appeal rights from the dismissal of his first four PCRA petitions. However, when defendant subsequently appealed the first four dismissals, the Superior Court of Pennsylvania quashed the appeal on the ground that the PCRA court had lacked jurisdiction to reinstate defendant's appellate rights since the fifth PCRA petition was time barred. During proceedings stemming from defendant's fifth PCRA, the trial prosecutor at defendant's trial, Joseph McGill, submitted an affidavit, which the parties heavily cite in defendant's current PCRA proceedings. Sorry, just give me one more second. Sorry, folks. Let me just see if I can get, Let's see. Link to live video. To join from her phone. All right. Again, apologies. We'll see. Let's continue on here. On January 3rd, 2019, 1 week after the PCRA court entered its order granting partial relief in defendant's fifth PCRA petition, the Commonwealth disclosed the court a defendant that it had discovered 6 previously undisclosed boxes of defendant's case file, in addition to the 32 boxes that had already been provided to the court for review, and defense counsel was permitted to review the 6 boxes. Defendant attaches several. Oh boy. Let's see. There we go. Okay. Input, output. Yeah, everything starts happening all at once. Okay, there we go. All right. Defendant filed his 6th counseled PCRA petition on December 23rd, 2021, initiating instant PCRA proceedings on June 28th, 2022. The Commonwealth filed Commonwealth's motion to dismiss defendant's 6th PCRA petition. On August 29th, 2022, the Commonwealth filed Commonwealth's response to defendant's brief opposition to the motion to dismiss. On October 26th, 2022, the parties presented oral argument. On October 26, 2022, the court filed its notice of a court's intent to dismiss without hearing defendant's petition for post-conviction relief pursuant to that statute. And then on December 26, 2022, the court again heard oral argument and posed questions to the parties. Through these questions, the court determined that the defense team had only reviewed the 6 boxes that the DAO disclosed in 2019. Prior to the PCRA judge, the Honorable Leon W. Tucker reviewed the remaining 32 boxes in camera for any evidence related to the issue raised in defendant's 5th PCRA petition. The defense team possessed that it had never been provided access to those 32 boxes. However, the defense team acknowledged that it did not request access to those 32 boxes and noted that we probably never expected we would be permitted to look through them for anything else outside of the Judge Castile issue. The Commonwealth stated that the defense had not requested to look through the 32 boxes. If they want to, we will allow that. There hadn't been a request. Still, perhaps not understanding that the defense counsel could have reviewed the 32 boxes of files anytime over the last 2 years by simply asking the DAO, defense counsel requested the court's permission to review the boxes, and the court clarified that a court order was unnecessary since the DAO was consenting to the file review. Because this file review fell at a late stage in proceedings, this court instructed the parties to present only the exhibits that they wished to introduce into evidence. Let's see. Okay. Let's see. Defendant's PCRA petition raises 3 claims. McGill's handwritten notes from the voir dire and McGill's affidavit provided during defendant's 5th PCRA proceedings constitute new evidence that renews defendant's Batson claim. Again, that's the part about the stacking the judge, or I mean, the prevention of black jurors from being placed. A letter written by eyewitness Robert Chauvert to the trial prosecutor Joseph McGill and postmarked after defendant was sentenced is Brady evidence that the Commonwealth promised to pay Chauvert in exchange for his trial testimony against the defendant. And again, in that December 16th hearing, the prosecutors straight up said it's not uncommon to compensate witnesses for the state, and that this should not be seen as inducing some sort of false testimony, but in just compensating their time away from work, et cetera, and so forth. A series of and the third one, a series of memoranda, letters, and notes written by several former employees of the DAO are Brady evidence that eyewitness Cynthia White testified against defendant in exchange for the Commonwealth's declination to prosecute 3 of her open prostitution cases. And again, there seemed to be, between Lynn Washington, Michael Schiffman, Johanna Fernandez, Todd Burrows, and the others that were in for instance, in the edited volume that Burrows put together, they seem to have very strong, compelling cases for why Miss White should not have been heard as a legit. So anyway, a claim warrants PCRA relief only if defendant pleads and proves by a preponderance of evidence that his conviction or sentence resulted from one of the grounds specified, and the claim has been previously litigated or waived. Has not been previously litigated or waived. Sorry for that. That's an important detail. A PCRA petition does not warrant an evidentiary hearing if the PCRA court reviews the parties' filings and relevant portions of the record relating to defendant's claims and is satisfied from this review that there are no genuine issues concerning any material fact that, if resolved in defendant's favor, merit PCRA relief. Here, defendant has failed to satisfy the court that there are any genuine issues concerning any material facts that need to be resolved at any evidentiary hearing. Wow. None of the defendant's claims warrant relief. Defendant's Batson claim is time barred and waived, and thus this court has no jurisdiction to decide this issue on its merits. Again, I'm far from an expert, but as I read that, she could be saying, I acknowledge that he might have had a case here, but I can't judge it based on that because I can't rule on it based on it being time barred. That would suck if in fact she was saying that and felt that way, because then you're acknowledging that someone who is being locked away forever has a legit case and is only not hearing that, being heard on that basis, on that case, on the basis of some time issue. That's in another level of whackness. I think we're getting. I think, anyway. And yes, I can provide this. I'll put this in the show notes, and probably should have done it already, but was rushing. So I'll upload it and make it available. Okay, wait. Okay, so just a second. Good. Because joining us now, this is perfect. I appreciate Dr. Burrows putting this together in the background. Joining us now, I will, let me adjust this here a little bit, is Zaid Muhammad, who, among many other things, is the author of the foreword to the book edited by Dr. Burrows, Trials of Mumia Abu-Jamal, a biography in 25 voices. Brother Muhammad, I appreciate you joining us. on this short notice and for these unfortunately bad reasons. But it's good to see you again. Greetings.
Thank you. And peace be unto you. All power to the people. Free Mumia abu-jamal.
Right on. So I was just going through the decision. I don't know if you had a chance to read it. I've just been going through and reading it with the folks here. But I can resume that here in a second. But let me give you a chance to give up any initial thoughts at the first hearing of this news.
Well, first, let me just say this. One, thank you for sounding the drum. Thank you for developing this kind of a drum. It's a good drum. It's a drum that we need. It's a drum that y'all have been using regularly and profoundly to lift some eyes and to turn our heads in the directions they definitely need to go, and to keep doing that. Um, it's just several very basic things. One, uh, everybody who has been involved with where we're at right now with Mumia, we anticipated the likelihood of something like this, right? And so tomorrow, we are asking everyone who has agreed to do this and those who are just trying to figure out what to do to rally at your local federal building at 12 noon, right? Because that'll be the next battleground. And because now I don't have any letters by my name like some other folks. So I'm not going to give you a legal analysis of this, but I'll just say that, so it's a great brother who, if you haven't had on yet, you should certainly have on the journalistic front. Brave brother, a colleague in Comrade Mumia by the name of Lynn Washington, has always described this rightfully as the Mumia exception, how Mumia has been mistreated in the law. At every turn where you think where there's this compelling evidence, turn the corner on his case, there will be demonstrations of how the law has turned in the favor of others similarly situated. But when it comes to Mumia, there's always this exception that will not allow them to do that, right? And then we should also say, too, that Mumia is not just in the clutches of the state. He is in the state of Pennsylvania. Pennsylvania, for folks who may not know, is one of the states in this country that specializes in giving out the most natural time of most states in this country. And so there are folks who die unnatural deaths in captivity in places like Pennsylvania and Louisiana and Texas, right? And Mumia is in the thick of that kind of captivity, So folks should understand it, and folks should also understand that at every Pennsylvania and Philadelphia in particular, tragically, has also been a profound house Negro factory, and their house Negroes have done some horribly destructive things to our people. No matter a facade of their beloved relationship to the mediocrity and the pathetic dimensions of the Democratic Party. Don't forget Wilson Good and what he did. How recently folks even tried to resurrect Good and name a city block after a man who bombed his own community, killed women, men, women, and children. And then they pull up this house Negro, Lucretia Clemons, who gives all matter of facade of being in tune with social justice and the historical urgency of now, even had produced a video for her in her church background. And it was all nothing but a facade. So as the great Amiri Baraka would say, I'm in Newark, New Jersey, cast away all illusions, prepare to struggle. Prepare to struggle.
Right on.
So we go to the next phase. We must continue to do all those things we do. I want folks to understand and appreciate that there is a younger generation, younger than you, Jared, right? I'm in my 60s now, right? But there's a younger generation trying to figure this shit out. And so what I'm suggesting in this Cop City moment, in this Tyree Nichols moment, in this Najee Seabrooks moment, in this Mumia Abu-Jamal still being denied his justice and freedom moment, that this new generation trying to figure this out, just as they were so willing to engage in massive civil disobedience in the George Floyd summer of 2020, need to continue, need to return to the streets for all of those reasons that I just tried to encapsulate, that put them in the streets several years ago and gave this country its hottest summer protest that has ever known. But not just mobilization, but the kind of organization that is necessary to on a day-to-day, month-to-month, year-to-year basis that genuinely moves work beyond the instance of our angry and necessary protests. So that, I mean,
No, right on. I appreciate that.
the legal scholars can do the legal dance.
Well,
I ain't no damn
I'm not a
lawyer.
legal scholar, but
I'm just a
we're
footnote.
we're being joined also now by Tova K. Welcome, Tova. And if you wouldn't mind, please introduce yourself and let us know what brings you this way. But thank you for joining us.
Sure, and thank you, but such an awful occasion to join. Yeah, I'm in Jersey and have been working with the People's Organization for Progress and the Mumia Coalition broadly to try to bring Mumia home. And so we're planning to be in the streets tomorrow at noon at the Federal Building on Broad Street to protest this awful decision by the judge. But that's what brings me here.
Right. Have you had a chance to see or read through any of it? And if so, did anything jump out at you?
I just read like the first couple paragraphs. It's a multi-page decision. And essentially she's just saying the same things she originally said back on October 25th when she had first indicated her predilection to just deny the decision outright. So we had all been hopeful that with all the vast amount of letters and voices chiming in, and the United Nations special commission on African American or African diaspora amicus brief that was submitted. We were hoping that all that would help her see that Mumia was really unjustly treated since his first arrest and trial. But she's gone back to her original predilection.
Yeah. So you're both welcome. I was going to read through a little bit more of the decision, and folks should know I've now put a link to the decision in the description to the show. So if anybody wants to see the full thing for themselves, they can. But I thought I would pull up some more of this. If either of you wanted to stick around, you're welcome to. And if there was something else you wanted to make sure you said, and without sticking around, please let me know. Otherwise, I will pull this back up here.
Oh, we can talk about it.
Huh?
We can talk about it. We can talk about it.
Okay, right on. Right on.
We can talk about it.
All right, right on. So I've scrolled down. I've skipped ahead to where she's coming to the what she's described here. That is Judge Clemons is the relevant facts. I've skipped ahead a little bit, having read her introductory paragraphs and then some of what the Mumia's team was arguing on his behalf, and started to read why she was denying it. But anyway, just reading from here, a very basic understanding of the facts adduced at trial is necessary in order to understand the context of the defendant's Brady claims. According to the trial record, Officer Daniel Faulkner initiated a traffic stop of a Volkswagen driven by William Cook, aka Mumia Abu-Jamal, defendant's brother. William Cook. The defendant's. I'm sorry, Wesley Cook is Mumia. William is his brother. Defendant's brother by the intersection of 13th and Locust Streets in Center City, Philadelphia at about 4:00 a.m. on December 9th, 1981. When police arrived at the scene, Faulkner had been shot in the upper back and directly between his eyes. Responding officers testified that defendant was found slumped just a few feet from Faulkner. Defendant had a bullet in his upper chest, and his legally licensed firearm was on the ground a few inches away from his hand. And as again, to your point, Brother Zaid, we've had Lynn here a couple of times, and one of the points that he's often reminded us is that they never did any of those tests to determine whether Mumia had fired a gun, whether the gun that he had matched the gun that would have killed Faulkner. None of this was ever done. And they, anyway. 4 eyewitnesses testified at trial, and defendant's Brady claims relate to impeachment of 2 of those eyewitnesses. First, Robert Chaubert, a taxi cab driver, testified that he heard a shot as he was dropping off a passenger at the intersection of 13th and Locust Streets, and he looked up to see a cop fall to the ground, and then he saw defendant standing over the cop and firing some more shots into him. He watched the defendant walk a few feet and fall by the curb. A few minutes later, police arrived, and Chaubert told police that he saw the shooting and then identified defendant as defendant sat in police wagon. Again, same thing, whether it was Lynn or Professor Schiffman and several others have pointed out, it's not likely at all that it was possible for Chaubert to have been there, or that he would have been there, or that he was there at the time to see all of this. So it's all very, I'm not seeing anything here yet showing how Judge Clemons ignores what they've had to say. So anyway, second, Cynthia, and I'm not seeing how what she is saying here contradicts what they've shown as problems with this evidence. Second, Cynthia White testified that she was standing on the corner of 13th and Locust Streets and saw a police officer pull over a Volkswagen and attempt to handcuff the driver. She saw the defendant run through a parking lot across the street, and when defendant got to the curb, defendant shot twice at the police officer's back. She saw the police officer turn around, and although it seemed like the officer was grabbing for something, but it was out of her line of sight. The defendant stood over the police officer and fired more shots. White was heavily impeached at trial, including for her record of more than 30 arrests for prostitution. At the time of her testimony, she was incarcerated in Massachusetts for a prostitution conviction and had 3 open prostitution cases in Philadelphia. The Commonwealth's alleged non-disclosure of Robert Chaubert's letter is not a Brady violation because it is immaterial to the defendant's conviction. Defendant correctly states that the prosecution's failure to disclose a witness's financial incentive to testify against the defendant could potentially violate Brady. Defendant asserts that the Chaubert letter is evidence that the Commonwealth offered Chaubert a financial incentive to testify against defendant, and that the existence of the financial incentive is evidence withheld by the Commonwealth that defendant could have used to impeach McGill. The parties agreed to the authorship, post-trial, post-mark date, and explicit content of the Chaubert letter, which includes its in relevant part. Mr. McGill, I have been calling you to find out about the money, I've been calling you to find out about the money owned or owed to me. So here is a letter finding out about money. Do you need me to sign anything? How long will it take to get it? How was your week off? Good, I hope. In McGill's affidavit submitted during defendant's 5th PCR8 proceedings, McGill claimed that the Chaubert letter follows up on a discussion that McGill and Chaubert had after defendant's trial, where Chaubert asked whether he could receive reimbursements for lost wages due to his participation of defendant's trial, and McGill responded that he would look into it. However, McGill claimed that he had no intention of looking into the compensation issue because he knew that as a policy matter, the DAO did not compensate witnesses for lost wages. A few reasonable inferences can be drawn from the Chaubert letter. 1, Chaubert and McGill had previously discussed Chaubert's desire to collect money and that Chaubert felt it was owed to him. Chaubert's letter was following up on that conversation after more than one attempt to call McGill, and Chaubert expected to hear back from McGill about this, but defendant makes additional inferences from the Chaubert letter that require additional support. First, defendant avers that because Chaubert does not reference a specific dollar amount, Chaubert must be asking for a sum that Chaubert and McGill had previously agreed upon. Second, and more importantly, wait a minute. that the defendant avers that because Chaubert does not reference a specific dollar amount, they must be right, of course. Second, they must have already agreed upon the amount, otherwise he would have mentioned it. Okay, right. Second, more importantly, defendant argues that Chaubert specifically expected a money payment from the Commonwealth in exchange for his testimony against defendant. Defendant further argues that the Chaubert letter is fundamentally inconsistent with McGill's affidavit because Chaubert clearly requests money that Chaubert believes is owed to him and appears to reference a previously agreed upon sum rather than offering a calculation of Chaubert's lost wages. It is unclear how defendant expects to prove these additional inferences through witness testimony or further argument at evidentiary hearing because, one, McGill's affidavit does not reflect that McGill will support these inferences. Two, Robert Chaubert was unwilling to sign a witness certification for defendant's private investigator. Defense counsel presents no successful attempts to discuss this letter with Chaubert. And defendant presents no other evidence that Chaubert remembers this letter written 40 years ago. Thus, there is no evidence on record upon which the court could credit defense counsel's bald assertion that upon information and belief at an evidentiary hearing, Mr. Chaubert will testify regarding the contents and context of the letter.
So why hide it?
Right. And then why not let him testify? Wouldn't it make sense, given the severity of the issue, to let him come up there and demonstrate under maybe even cross-examination the shortcomings of his memory or his claim? Wow. Okay. However, it is unnecessary to resolve these factual issues at an evidentiary hearing because defendant cannot prove that the non-disclosure of this letter prejudiced him. Wow.
Really? This is so,
okay.
Really?
Assuming arguendo. Yeah, go ahead. I'm sorry.
Tova's right. Clemons gave this facade when we really started putting some international pressure on her court around this hearing, that we need to look at this evidence, right? She gave this beautiful facade, but it was nothing more than a facade. This is the same stuff that she was aping when she was originally going to dismiss this on stuff, was not so willing at all to address the fundamental dimensions of fairness when evidence has been withheld from somebody whose life is on the line and who may have been, and there's so many levels of this. She dismisses everything, right? Everything. Batson, we know that Philadelphia DA not only loaded the court with white jurists and made a mockery of Batson, but had a videotape that trained DAs on how to eliminate black jurors, right? Yeah. And that was fully in effect in Mumia's case and other cases. And other folks have gotten off on that premise, but Mumia's an exception.
And she did sit in there that day when we were there on the 16th of December, and you could see her all day, presiding over these people's cases, and she would come with that, "Oh yeah, baby, come on, step forward. It's okay. Have a seat, sweetheart. It's okay." She had that very performative. Yeah. And it was oh man. Continuing here, she says, assuming arguendo that defendant could prove by a preponderance of the evidence at an evidentiary hearing that the Commonwealth promised Chaubert some form of payment to incentivize his trial testimony against defendant, then defendant's Brady claim still fails. Even if the jury had heard that the Commonwealth had promised to give Chaubert some additional form of payment related to his testimony against defendant, that impeaching information would not have been sufficient to undermine confidence in the outcome of the trial. Really? Wait a minute.
She put her name on this.
Wait a minute. Whoa. Even if the jury heard that the Commonwealth promised additional payment related to his testimony against defendant.
I need to tell you, Jamal Jr., Mumia's grandson, is about to join.
Oh yeah, great.
Good.
No, good. Great. Thank you.
Jamal's starting to look like his grandfather. Yeah, bring him on. He's been making noise.
Oh my goodness. Wow. So she's saying, even how can she determine that?
Exactly.
Role she's playing. I want folks to understand too how she got to this position in the trial. I can say this, right? We got this far and thought we had an opening when we were before another judge, another black judge, Judge Robert Tucker, who happened to be a black Republican. You can't make this stuff up. But he was for all of his Republicanness, or whatever that means. He was not. He was man enough not to be intimidated by the PBA and all that facade that they came into court with, and just stood on principle and said, this evidence is been withheld. It needs to be examined. This man needs to be considered for retrial consideration. He did that. He was removed from the case. It should have been before him. But they came up with this some kind of wrinkle in the Pennsylvania common law. And again, I'm not the lawyer on this, that gave them an out to put this before another judge. And so to cover themselves in their racism, they found another Negro, right? And here she is, and she did just what they do. And they're very good at it in Philadelphia, by the way. They're very good at it.
So we're bringing in Professor Michael Schiffman.
As you bring him in, let me just say this, Jack, because I'm not going to be able to stay on long because I have to actually do another show in a few minutes.
Yeah, I hear you. Okay.
You opened up referencing Todd Burrows in his book.
Mm-hmm.
Todd Burrows' book is going to become more important than it ever was just by virtue of this decision, because it has in it, there you go, lift it up, all of the evidence that the whole world has already seen that is the basis for Mumia should not only being free, but should have been freed years ago, right? And let's welcome Michael Schiffman, because he contributed to the development of that evidence, and that's important to appreciate. So right on. I appreciate Black Power Media. Y'all keep sounding the drum. All right.
Appreciate you as well.
And as he joins, I'm going to leave. Thank you.
Okay. All right, Tova, thank you very much. Appreciate you very much. Thank you all for coming through. And anytime, you're welcome back anytime. Thank you.
Keep sounding the drum, baby. All good.
Likewise. Take care of yourself. Free Mumia. All right, Professor Schiffman, good to see you again. Again, not, under the appropriate circumstances. I've just been reading through the decision here, and we're just at the section where she's explaining that even if apparently a jury were to have heard, or if a full evidentiary hearing were to be heard regarding Chaubert's evidence or lack thereof, it would not have had any impact on a decision, or which seems incomprehensible to me. But let me give you a chance to give you any of your first thoughts. I don't know if you had a chance to read that much of the decision, but go ahead.
I skimmed through the Batson part, which is the major part of the decision, very quickly, because we already know what they are saying in things like that. It's untimely. It's untimely. It's untimely. They are saying the opposite.
Time barred.
Yeah. They are saying of the opposite of what's in the amicus brief of the United Nations expert group, where they say racism has no time bar. For them, it has, and it's been litigated, and it's over. So let's concentrate on the two things, on the Chaubert claim and the White claim. It's very curious to read that. Mainly, they say, for one thing, they say, okay, it doesn't have to mean anything. It has an innocent explanation. But the major part and the scandalous part really is that the judge now says, well, even if it could be proven that Chaubert got money and that White got leniency, it wouldn't have changed the outcome. So that's probably news to any TV watcher.
I mean, how could they say that? I mean, that's just so crazy. Like if you're sitting in a jury box and somebody says a witness was paid to testify against the defendant, how would that not have any impact?
Exactly. And these were the two first witnesses. Robert Chaubert was the very first prosecution witness on the 19th of June, of all days. June 19th, Robert Chaubert told his lies, and had the jury learned he got money for it, I think some people would have scratched their heads already. Then the next witnesses for 2 days is White. And if the jury had learned that she was promised leniency, I think that would have been the point where most people would have said, okay, that's enough. We don't want to hear anything more. That's basically it. And apparently not to the prosecution and not to the judge. And the fourth point is that she also says, okay, even if they discounted these 2 witnesses, there was so much other material that would have convicted Mumia. And the other material was a witness, a motorist, who at the trial said, well, I really don't know whether Mumia shot Faulkner in the back. I assumed it. That was one of the good points that Anthony Jackson, Mumia's trial lawyer, managed to make. That Scanlon said, I don't know whether Mumia shot first. And that's the evidence on which Mumia was convicted. Add to that the false confession at the hospital. It's also bogus.
So, if it's all right with you, I'm going to read a few more pages or a little bit more on here. And then and when Sophia Williams, who it looks is set to join us, is ready, we'll invite her up. She is, of course, among many other things, the leader of the campaign to free Mumia. And I think she's ready. Sophia, greetings to you. Welcome to the program.
Good to see
you. Good to see you and to more or less meet you. And I appreciate your work for a long time from afar. But we're just reading through the decision of Judge Clemons. But let me get your initial reaction if you've had a chance to digest any of it.
Well, thank you for this time. I do really apologize for my background noise.
Yeah,
I hope it's
not. I'm sorry. There's something with your mic. It's coming in very scratchy and hard to hear.
Let me give me 1 second.
Okay, and maybe if you pull the mic away, I'm not sure if it's on your jacket. Anyway, Anyway, just what she's saying here. First, impeaching information about Chaubert's financial incentives to testify is not particularly persuasive because Chaubert immediately and steadfastly identified defendant as the person who shot Faulkner, and Chaubert never changed his statements or testimony regarding the shooter's identification. So she's saying that because he always said Mumia did it, there's no reason to claim that he was paid to say Mumia did it.
Yeah, and then she says, okay, there were some contradictions in his testimony. For example, that he first said the shooter ran away. And that's a small lapse for her. So she says, first he says, one thing that she doesn't say is, the first thing Chaubert said at the scene to Inspector Giordano was the shooter ran away.
Yeah, she doesn't have that in here.
She doesn't have that in her. She suppresses that. Second thing he said after he was at the police precinct and learned that Mumia had been arrested at the scene, he said he ran 35 steps. And that's a small lapse for her. 35 steps on the one hand and 10 feet on the other hand. That's not a contradiction for her. And then the other argument she brings about Chaubert and White is they were both thoroughly impeached at the trial.
Right.
They were questioned very thoroughly, which is not true in the case of Chaubert, but which is true in the case of White. And all the contradictions were brought out. And so the new evidence, if it is counted as new evidence, wouldn't have changed anything. But it might very well have tipped the balance, and that's the point that she never entertains.
No, she just said, I'm sorry. Yeah, I'm sorry. Go ahead. Sorry, go ahead.
The new evidence might have been the crucial last drop in the bucket to tip the whole balance. And that's a possibility she never entertains, curiously.
Yeah, she just says that the discrepancy in the 30 or 10 feet could be a lapse in measurement. And because the defendant fails to point to any other material difference between Chaubert's statement to police and Chaubert's testimony at trial, it is difficult to understand how any financial incentive impacted Chaubert's testimony.
Yeah, that's also
except that she doesn't deal with all of what you and others have brought to our attention over years, really, but again, recently, around the question of, could Chaubert have been there in the first place? Why would he have stayed?
Absolutely.
And then which all of which would have been answered by, he was incentivized through payment to say he saw what he said and stayed to see what he could not have been there to see, and would not have stayed to see, because he had his own issues with illegal licenses or whatever, right? He was not in a perfectly legal situation where he would have wanted to stick around a murder scene of a cop to bear witness.
And apart from that, she deletes another crucial discrepancy, which is actually agreed upon by all sides. In his initial statement at the police precinct, he said the shooter weighed about 220 to 225 pounds. And Mumia was weighed at the prison hospital. He weighed 170. Is that a small discrepancy?
That's not a Sophia. Let's try to have you back again. It's good to see you again. Welcome back. Let's try to give us your initial response to all of this.
Well, yes. Thank you for having me. Is it still not coming through?
Yeah, the sound is just very scratchy. I don't know. I'm not sure what is your mic brushing up against, or those Bluetooth? I'm not sure what it is. We'll work through it. Let's you said you only have a few minutes anyway. Let's work through it. I'm sorry. Go ahead.
Yeah, thank you, Dr. Ball and Michael and all the others that have been on and being able to just host this emergency kind of discussion. I actually just got wind of it myself after coming out of a situation, and I really haven't been able to look into it, but I am following it by listening to your program, and it has been, disheartening on many levels. And I believe it was Tova who said that it just seems like everything she said at the end of October is what she's repeating yet again. And all that, whatever that she did as research and all the great work of Mumia's lawyers, I cannot understand how none of those made a difference in her decision now. And just seeing some of the lines here that you're pulling up, Dr. Ball, I again, and I'm listening also to Michael Strickland here, Professor Strickland. I again, it doesn't make any sense. It's a matter of just doing the same things that has been done over the years, lack of effort, and just, again, it's almost like it's a training at this point, how to handle Mumia's case if you come into contact with his case. Because this does not represent somebody who speaks the game of justice and doing what's right. And the video that, we've seen, and being a woman of color, those two things she has, and being a woman of color who's in a high position, this doesn't add up. And it doesn't surprise me, but it also is highly upsetting, because so much has been put into creating a strong case, and it's as if no work on her part happened. I don't understand what happened between October 25th, what felt like a reopening, a moment of, caution, optimism at the end of December, and her saying she wants to not have this case going on and coming back with something like this. It's disappointing for someone on her level, and it's also telling of the system that we continue to fight up against. But we continue to fight, and we will be in the streets nonstop
No question.
until Mumia is freed.
So, Sophia, please come back anytime. I'm gonna let you go. I know you're in
Yes.
a tough spot, and we'll have you. You're welcome back anytime. And whenever you all get your response together and figure out your next steps, please come back and let us know what they are so we can help support them. And thank you very much for your work.
Thank you,
Yeah, thank
and
you,
blessings and
Sophia.
solidarity. Thank
Peace,
you.
peace. Yes, indeed.
Michael.
Thank you. Yeah. Anyway, that's we'll definitely look to have her back when
Right.
and like I said, when she gets a chance to look through this. Let's see. Second, she continues here. Second, at the 1995 evidentiary hearing, Chaubert testified that he did rely on McGill for at least one benefit, assistance with getting his license reinstated. But that benefit did not change his testimony. So that's a weird way to introduce the fact that he didn't have a license the night he was there, right? You know, right?
Yes, absolutely, absolutely.
Oh, man.
Things that McGill then said, or that the prosecution said in 1995, that McGill never did anything about the license, so he denied it.
Oh, wow.
Wow. That's an additional thing, and to add another wrinkle to it, turned out at the 1995 PCRA that Robert Chaubert never got his license back. He continued to drive a school bus and taxi cab without a license, without ever having more to do than paying a fine. Never went to jail for it. If that is not preferential treatment, I don't know what is.
Oh, man. For all of these reasons, even if defendant were to call Chaubert as a witness and Chaubert were to contradict McGill's affidavit by claiming that the Commonwealth had promised him money related to his trial testimony against defendant, that admission would not be sufficient to carry defendant's burden. Therefore, defendant's Brady claim about Chaubert lacks merit.
Yes, and what that also skips is what would happen if Chaubert and McGill were there? Basically, if this is a real evidentiary hearing, they could be asked anything. They could be asked all the pertinent questions, for example, about Chaubert. How come you pulled up behind a police cruiser driving without a license while being on parole? How come you saw shots fired into the sidewalk, shots of which no traces are there? How is all of this possible? That could be asked at an evidentiary hearing. And so the judicial system has very good reasons not to have that evidentiary hearing.
Except Judge Clemons gives them an answer to that too, right? In her line about this could all be dismissed as his bad memory or poor measurement. He could have been,
right.
I mean, that's the, but I mean, anyway. All right, just a few more pages here. Defendant was not prejudiced by the Commonwealth's alleged non-disclosure of the Commonwealth's leniency and Cynthia White's future prosecutions in exchange for her testimony. You along with Lynn Washington have I mean, this is anyway. Defendant attaches to his PCRA petition a series of 7 memoranda, notes, and letters authored by various former DAO employees as proof of defendant's Brady claim that the Commonwealth promised to drop Cynthia White's 3 open misdemeanor prostitution cases in exchange for her testimony against defendant.
I mean,
yeah, go ahead.
There's a very simple question. You know, at that time, prosecution was illegal in Philadelphia formally until 2018. And so you have 7 memoranda for that one prostitution alone. Do they do that with each and every prostitute in Pennsylvania? No wonder the judicial system is clogged. If they are busy writing memoranda about each prostitute who has a case, I mean, that's not the normal treatment for just any other witness. So she was given special importance, and all of her 3 cases were dismissed on one day.
And McGill, again, remind us who McGill is again in this. why is this McGill affidavit so important here?
I mean, when the new evidence cropped up, McGill did an affidavit, which is very long, 7 to 10 pages, in which he basically denied everything. He said, I didn't give money to Jobert. I didn't give preferential treatment to White. It's all a lie. I was totally correct in everything I did.
All right. Finally, defendant heavily criticized the statements in McGill's affidavit, including McGill's avowals that he never took any steps to intervene in the prosecution of Cynthia White for any crime and never suggested, directed, or otherwise influenced the outcome of her cases, and absolutely had no agreement with her to do so in exchange for anything. I mean, but so unless he says I did it all and I'm guilty, they can't put a case together. I mean, so no other evidence matters if he just says no, it's not true. Because anyway, at least on my first reading of this, in my inexpert first reading of this, it feels like Judge Clemons just keeps saying, because McGill says it's not true, everything you all are arguing can't be right.
Exactly. And she says, because just because Jobert said this thing and always insisted he told the truth, it must be the truth, and we can't even question him about it.
So then she says that the defendant would be unable to prove by a preponderance of the evidence that an evidentiary hearing that White formed a deal with the Commonwealth to testify against defendant in exchange for leniency.
In normal understanding, in the understanding of the normal layperson, an evidentiary hearing, you have that in order to solve the contradictions that have cropped up in the course of a case. And what Judge Clemons does here is she knows everything beforehand. She knows what the outcome of the evidentiary hearing would be before having the evidentiary hearing. And that's not the normal conception.
Mm-hmm. Let me just bring up, and we're honored to have him join us, Jamal Ibn Mumia Hart III. Welcome to you, Jamal. And if you would, if you're hearing me, if you would, if you want to just say hello and quickly tell everybody who you are, and then we can invite your first run thoughts of this unfortunate decision. And it's good to have you. Thanks for joining us.
Peace. How are you doing today, Dr. Ball? And I'm glad that you can mobilize, media so quick. When the news hit us, as much as all of us know that we've been checking every single day for this news. And for all that's watching, and for all of you that's watching, my name is Jamal Ibn Mumia Hart III. My Mumia abu-jamal's grandson, eldest grandson. And we have a program called Love Not Fear. Currently, I'm pretty sure a lot of you have seen the logo going around. And, we're just trying to mobilize this world movement around the freedom of my grandfather.
Right on. Yeah, all I've really been doing is just reading the decision here and inviting folks to comment as we go. And so you're welcome to join us and stick around as long as you have. And if there's anything you want to make sure we know about or get off your chest or share with us, please do. And of course, you're always welcome. Anytime we can support what you got going on, we're happy to do that. So thanks for jumping on here.
We're a world movement, I think when we saw what the workers have been doing around the world with shutting down ports, and we started seeing a lot of solidarity with unions, we were reminded like how powerful and how much solidarity comes into Mumia abu-jamal's movement. Michael Schiffman, like has some of the best materials, like walks on a crime scene for Mumia abu-jamal's case that I've ever seen. And for a sitting judge, it really, it's disappointing, to say the least. We in 2018, we had Judge Leon Tucker, right, was the first judge or any like official in Philadelphia say what we all knew, right? Like we all knew that it was a sham trial. We all knew that, the prosecution and the police took liberties, to say the least, when it came to framing up my grandfather, and for him to kind of move up, and for Lucretia to come in, right? And we're all looking at the history of Lucretia. We're trying to do our homework and everything, and for her to really give us this slow burn to say, I dismiss, his PCRA claims, where it's evident that the witnesses, the supposed witnesses in my grandfather's original trial were, tampered with, of course, even, it's heartbreaking, right? Because, like many of you know, because I've talked to you, personally. Many of you know that, like, he's not just some famed journalist to me. That's my grandfather, right? When I look at him, I see my father, right? And Mumia is, if he's not anything, he's just a scholar, man. He's just a good dude, who's being framed up by Philadelphia for a murder he didn't commit. And the judge knows this, the prosecution knows this, and it's really saddens me that they won't give my grandfather the freedom that he deserves.
Right. I mean, yeah, right on. Thanks for that.
I mean, there's one thing. It does really seem to be not just against the spirit, but against the letter of the law, because the law is quoted in the decision. It's all about so-called materiality. So even Judge Clemons says, okay, this seems to be new evidence that has been suppressed, but there is a third criterion: the evidence has to be material to the case, and she says it's not material. And to quote from Brady itself, Brady evidence is material, quote, if there is a reasonable probability that had it been disclosed, the outcome of the proceedings would have been different. That's one decision. And another one is reasonable probability is a probability sufficient to undermine confidence in the outcome. That's what we just discussed. I mean, two witnesses in a row, both of whom were bribed. That should be material evidence. That should be as clear as daylight. So that's the crucial question in this case at the moment: materiality. And now that Judge Lucretia Clemons has turned us down, the focus really has to be on the district attorney's office, which takes the very same stance on materiality.
Michael, 1 second. I want you to come back to that point. I just wanted to show here on the screen, just skipping ahead to her conclusion here, to summarize what you just summarized for us, which she summarizes in the previous pages, and people can read in detail on their own. The link is in the show description. In sum, she writes, defendant's Batson claim is time barred and waived, and defendant's Brady claims are meritless. Therefore, defendant's 6 PCRA petition is dismissed without an evidentiary hearing. So to your point, Michael, she's saying even if they had heard that evidence, even if it wouldn't have meant anything, it wouldn't have meant anything. So there's no point in hearing it. And the other evidence, which may have been relevance, I can't consider because it's time barred. So it's like a nice little convenient, anyway.
So you lose.
Exactly. So unfortunately, I do have to leave in a few minutes. But so let me just get you. I do want to, Michael, have you pick up where you left off in terms of what next steps are, and then Jamal, same thing. Where do we need to start heading and moving our focus as it pertains to Mumia?
Just briefly before I hand over to Jamal, who should have his say on this, I think the really important thing now is to hold Larry Krasner's feet to the fire. he has assigned two of his most terrible prosecutors, really old-style people who come from the Castile and Lynn Abrams time, and to act accordingly. And we need to ask the Krasner office, the progressive people who are there, they are there, and he himself also in many regards is progressive. Do you really think this is the meaning of Brady? Two witnesses are bribed, the most important witnesses of the whole trial who come at the beginning are bribed, and the jury says, oh, that doesn't matter to us. Is that your understanding of justice? That's the question we need to be
but does Krasner, I mean, what, forget my ignorance, but does he have, what does his office have the power to do here?
Well,
like after all these rulings and decisions, what could Krasner, can Krasner overturn anything? Can he demand a new trial? Can he?
He could say, I'm withdrawing these prosecutors, and I give the charge to somebody who has a conception of justice that the ordinary person can understand, and that's in accord with the law.
Okay, all right, Jamal. Any idea yet where you think we should be headed? And again, all of you are always welcome back here throughout this platform to keep us up to date and help us support what you're doing. So, but yeah. Jamal.
Well, you know, I was actually on my way to go see my grandfather when this news just came down, and this kind of derailed a little bit. But I think when we talk about the case of Mumia Abu-Jamal, it's in the same place where it's always been. For the people that are in the position to do the right thing, they do just that, right? They do the right thing. Larry Krasner cannot be a stickler for Brady, right? And then be silent when it comes to the injustices that Mumia Abu-Jamal had to endure in this racist court system. And, you know, when we talk about progressives and when we talk about people that want to do the right thing, nobody's doing the right thing when it comes to Mumia, right? And it's likely because of fear, right? It's because of fear that in Pennsylvania, in Philadelphia, in particular, I think a lot of people don't understand how fearful the residents of Philadelphia are, especially those that are in positions, right? And everybody. Well, what's next, Jared, is, you know, we are going hard in the streets. That's next, right? Tomorrow is there will be rallies everywhere in the world. There will be rallies for this decision. What's next is that we're going to keep holding their feet to the fire, right? Just because they want to dismiss my grandfather's lawful claims, right? We will not stop. We have to do the things that we can do, and what we can do, we can definitely cause a ruckus, right? Because this is not a quiet, like go quiet into the night type of scenario, right? This is crushing to so many people, A lot of people have fought for the freedom of Mumia Abu-Jamal the majority of their lives, right? The majority of their lives. And, you know, I'm looking at the emails of people waiting for her decision, right? She said her decision was going to come down about 2 weeks ago, a little over 2 weeks ago, right? And they're waiting and they're anxious, you know, and they say like I just can't, you know, this is a lot. And this is really affecting a lot of people's heart, right? Because Mumia is the community. Mumia is the world movement. Mumia is the heartbeat, you know, when we talk about revolutionary, you know, thinkers. And, you know, Mumia represents all that are in prison. Mumia's story of as a political prisoner is the story of your family members and your friends who are being held behind bars, you know, from a racist system. So we're not stopping, Jared. We're not stopping at all.
All right, on. And Anthony, I think, speaks to a lot of our consciousness right now. Please extend our best when you see your grandfather. Love and support, and I'm assuming people can find the address where to write him at, either through Love Not Fear, through Prison Radio, through freemumia.com.
Well, I can tell you, Jared.
Mhm.
I can tell you, like, as soon as I talk to him, he's going to be like, "We just got to keep on keeping on, right? We just going to keep fighting. We're going to keep hitting them in the teeth, because that's the power that we have, right? We are the most powerful force in the people, the most powerful force in the world, right? We have to remind ourselves that and move as such, as a world community, for the freedom of not only Mumia Abu-Jamal but all political prisoners."
Yeah, right on. Well, Jamal, Michael, thank you very much for jumping on at this short notice. Once again, you're always welcome here, and anything I and we as a platform can do, just holler and let us know. We got your back. And again, a peace to you, peace to your grandfather. Thanks to both of you for all your great work, and look forward to catching you another time, hopefully under some better circumstances.
See you at the front line, Jared.
There you go. Right on. There it is. Right on. Thanks. Thanks. Right on. Peace to you both. Thank you. All right, everybody. Just a quick response here, initial response to this bad but unfortunately not surprising news. So continue to support Mumia, all political prisoners, including those who are soon to be targeted as future political prisoners, probably, unfortunately. So let's keep up the good work. And as Fred Hampton used to say, peace if you're willing to fight for it. Catch you next time here at Black Power Media. I mix what I like, and the entire platform. Thanks everybody for jumping on, who are able to now, and to those who will see and hear this later. Thanks to you as well. Yeah, free Mumia, free them all.
I mix what I like, what I like, what I like, what I like, what I like.